My name is Raul Ayala. I'm going to moderate this August panel. I know we're the last panel between you and that first drink. And believe me, I know what that means. I would first like to thank Sandy and the section for inviting me to put together this panel on a very important topic. As you can see from the last panel, they set it up very nicely, right? Immigration is a hot topic. It goes without saying that almost every day since the inauguration, basically, we've had issues related to immigration and travel bans and those kind of things. And so as Sandy asked me to put together this panel to talk about what kind of effects this increased focus and increasing enforcement escalation will have on the criminal justice system. So we have three able-bodied and very knowledgeable individuals for this panel. Our first, I'm just going to go alphabetically. Chief Anthony Holloway is currently the Chief of Police for St. Petersburg here in Florida. Before that, he started his career at Clearwater, eventually became its Chief of Police, who was over also in Somerville, Massachusetts, as its Chief of Police. Has both a bachelor's degree in business administration, master's in business management, and a couple of other certificated programs that he did through Harvard. Was also a professor and very active in his law enforcement community. Chief, welcome.
Thank you.
Also with me to my immediate right is Abide Musavian, who is a senior policy attorney for the National Immigration Law Center. She's got quite a bit of experience in immigration, policy and practice. She was with the New York Immigration Coalition, worked with Families for Freedom, an anti-deportation community organizing network in New York City. Also a visiting professional at the Office of Public Counsel for the defense at the International Criminal Court. Has her JD from Boston University and a bachelor's from Columbia. Welcome, Abide. And last but certainly not least, we have my California colleague. We're both morning blue, if you know what I mean, for those of you that are baseball fans. Angela is the Senior Assistant Attorney General for the state of California with our new and very active and progressive Attorney General, Javier Becerra. She heads the Attorney General's Civil Rights Enforcement Section. She's been with the DOJ for over 30 years. Maybe we can truncate that down to 3 decades. It might sound a little bit better, but for us, we've been around for a while. Her areas of interest and specialty are immigration rights, police practices, reproduction rights, the Native American cultural protection, access to education, and others. Her undergraduate was at UC Santa Barbara, and her JD was at the UCLA. So thank you for joining us, Angela.
Thank you.
I am an immediate past co-chair of the Immigration Committee, and moving over to Alternative to Incarceration Committee. So I've been involved with the immigration issues for a while now, with Kevin Curtin and Wendy Wayne from the Commission on Immigration, and others were able to get Resolution 10C passed at the summer annual meeting regarding including courthouses in the definition of sensitive locations, urging Congress to amend INA Section 287G to expand the definition to protect our courthouses in light of escalating enforcement at the courthouses around the country. So I'm going to start with you, Abide, just as a primer, if you will. How is immigration law enforced? We understand that there are statutes, rules, regulations, rulings from the Board of Immigration Appeals, U.S. Court of Appeals opinions, Supreme Court opinions, but how generally is it enforced, and who are the players in that? Thank you.
Is this on? Okay, thanks. So by way of just sort of giving an overview of the landscape of what rules apply and who are the enforcers of immigration law, I would say there's been a lot of changes under this administration, but still, kind of historically speaking, there's the Immigration and Nationality Act, it's the INA, that's the law that governs immigration laws in this country. And there are regulations as well as DHS policy that changes from time to time, but we do have some longstanding policies that we're seeing sort of how they play out under different administrations. There's the immigration courts, which are administered through the Executive Office of Immigration Review, or EOIR. That's under the Department of Justice. And the judges are staffed through EOIR, but the attorneys for DHS, it's administrative proceedings. And I think an important distinction that many people don't know about is that there's no right to counsel in those proceedings. So that's regardless of your circumstances, regardless of the relief that you're seeking, regardless of whether you're a 3-year-old unaccompanied child, if you're indigent, none of those things that may apply in other court proceedings, and certainly in the criminal justice system, apply. There are a lot of efforts locally to try to create a universal representation right that's publicly funded, that's happened in parts of the country. In New York, there's efforts in Los Angeles and throughout California and in other parts of the country to really say that nobody should have to face the life or death potentially life or death threatening consequences of deportation without an attorney to help them navigate the system. And you may have seen, particularly in the last couple of years, as there's been an increase in the number of unaccompanied children in court proceedings. That's kind of the starkest example of just how harrowing the system is. And for those of you who have practiced immigration law or work with immigration practitioners, the joke or the commiseration is always that it's harder and more complex than tax law. So again, the idea that we're sending people through a system completely on their own is very daunting for most people. And then in terms of what we're seeing now, sort of trends nationally that are ultimately discretionary and left to states and localities to define how and when and under what circumstances do they want to play a role in immigration enforcement. They're not obligated to by any means. They're not obligated to share information about people's immigration status or to collect it. In most cases, I think that's something that people hear a lot about, and it can be confusing, but in fact that there's long-standing law from 1996. There's a provision, 8 U.S.C. 1373, that's very, very narrow in scope, and basically says that there's only limitations with respect to information about a person's citizenship or immigration status, that you can't put limits on whether or not you share that information with federal agencies, but there's not an obligation to collect that information in the first place, and it certainly doesn't pertain to other information about that person, including their date of birth, their date of release, the charges against them, the posture of their criminal proceedings. So there's no obligation for localities to engage in immigration enforcement, despite sometimes hearing things that suggest that localities are somehow obstructing or not playing the role that they're supposed to. And there's also specific policy that's been in place since 2011. It's sometimes referred to as a sensitive locations policy or the sensitive locations memo that basically is the Department of Homeland Security, and maybe even taking a little bit of a step back, that's an agency that was previously INS. Sometimes people still say that, even though we're approaching the 15-year anniversary of DHS. It came into existence in 2003. But under DHS policy since 2011, they have recognized that certain places, just as a matter of public policy, that it's not in the best interests of the community to engage in immigration enforcement activities in those places. And those places include schools, hospitals, places of worship, protests, or places where people are essentially exercising their First Amendment rights, as well as religious ceremonies, weddings, funerals, public events of that nature. Courthouses are not explicitly named in the definition of sensitive locations, but they have been recognized as holding a special place because the role that they play in access to justice. Again, that's the written policy on 4 corners of paper. It's a very different reality that I think we'll get into in the panel about how that's actually being honored and what the future of those types of policies and protections are. With respect to who else is enforcing immigration, where does it get enforced? Within the Department of Homeland Security, there's Customs and Border Protection, and many people think that that's limited to just the physical borders. Obviously, CBP is also in ports of entry like airports, but we're also increasingly seeing that CBP is often collaborating in other ways with local law enforcement, and it's not just limited to what you would imagine is just the very literal physical proximity to our border. ICE, or Immigration and Customs Enforcement, that's the sort of largest wing of the Department of Homeland Security's enforcement personnel force, and there's been a lot of talk about this administration wanting to increase the number of ICE personnel. There's been a lot of talk about wanting to increase the number of detention spaces for people. Those all sort of feed into one another, and the purported need for more ICE personnel. Our organization's position, obviously, is that we shouldn't be increasing the number of people who are subject to immigration detention, and that ICE, particularly now under the current system where there aren't really any parameters for who's a priority. Historically, there's been the concept of prosecutorial discretion. This is very familiar to you all in your work. Obviously, you don't treat a jaywalker in the same way that you do someone who commits an armed robbery. But in immigration, even though the laws on the books may say one thing, there's always been the possibility and the room, and in my view, both the authority and the tool, the law enforcement tool of exercising discretion. That's been in numerous ways. Sometimes it's been to a particular class of people. So the kind of most publicized example is the Deferred Action for Childhood Arrivals program, or DACA program, for people who came here in their childhood and grew up here. But there's also a lot of room on individual case-by-case discretionary basis for humanitarian or other reasons for ICE to exercise discretion. So those decisions get made often at the field office level, and not necessarily always at headquarters. So there can often be what feels like a variance in how our immigration laws are enforced, depending on the culture and the relationships with the community, with law enforcement, with advocacy groups. And then similarly, within the immigration court system, there can be often a great disparity in terms of the percentage of relief given. So if you look at, for example, asylum rates nationally, they are abysmally low in a place like Atlanta, Georgia, as compared to New York City. And that often sort of feels like justice is random, and despite the fact that there should be uniformity in the application of the immigration laws. I'll pause there, see if you have any questions.
So you mentioned, of course, there's law enforcement officers within the federal government, through CBP and ICE, and you mentioned that oftentimes there's a connection with local law enforcement. So, Chief, why don't you tell us a little bit about your perspective of how you've seen traditionally the relationship between local law enforcement and federal immigration law enforcement officers, and where you've seen the shift in that policy, and what trends you may be seeing in the future?
Sure. So I've been involved in law enforcement for about 32 years, starting when I was 12, so you can figure out the numbers. If you go back, you start looking at, in 2000, that's when the year I was working in Pinellas County, the population for Hispanics was about 10%. Today I can tell you the population now is about 25% of the city. So when we first started looking at it, we were working with ICE, and we had this approach where we were going to try to enforce immigration. What we realized when we were doing that, we created almost like organized crime, because from there people were running away from the badge and running instead of running to the badge, because we had a lot of victims that were being robbed, that were being involved in homicide, that were being involved in human trafficking, because they were afraid that if they came as a victim, they were going to be deported. So the philosophy changed with the federal government, and everybody remember that program called Weed and Seed. So at that time, the police department decided to open up a Hispanic outreach center right next to the police department. And that was telling the people to come in. Whether you're documented or undocumented, come in. And if you are a victim of a crime, we need to know because we need to move that element out of the city. We contact our federal partners and said, this is what we're going to do. We're going to no longer try to deport everyone. We're going to try to figure out who our victims are and how can we stop this organized crime being developed in our city. Most of the people that were moving into the Pinellas County area in Florida, they were from a town called Hidalgo, Mexico. And once we started getting involved in that community, we found out the average person, the average undocumented person, was getting robbed every other day because they were afraid to report because they couldn't go to the bank, so they were carrying the cash. And the suspects would know on payday there's a good time to go rob them because they're not going to report that crime. We also found out as we started getting more into it is the landlords. You're not going to report to a landlord that something's wrong because if you go to police, you're going to be deported. So therefore, pay your rent and we're not going to help you out with your living condition. So at the time, local police department, code enforcement got together and the rule was not to ask if the person was documented or undocumented. The question was, are you a victim? And we go back to that buzzword everybody talks about is community policing. If you are community policing, then you need to act like community policing because you are the local person there. When things go sideways, people are going to depend on you. So back then we said, if you want to survive as a police officer, you need to know your community because when things go wrong, the people that are in the community are the ones that are going to come to you. So we saw that in 2000. Fast forward now to this year, to where we are right now, I can tell you over 60,000 people have gone through the Hispanic Outreach Center and they're reporting crimes. And we saw a spike in crime because victims came forward, and then we saw a decrease the following year because those suspects no longer knew that they could rob that person. It was not going to be a follow-up to that. The landlords knew that they had to bring those properties up to the right level if they were renting to anyone else. We actually started a human trafficking task force within 3 years of that, and we were able to get into that network because the trafficker was telling the people that they were trafficking in, if you go to the police department, you were going to be deported. And guess what? We did exactly what they said that we were going to do. So we changed our philosophy in that, and we were able to stop our human trafficking within our city, and we started a thing in the Tampa Bay region. Again, the robberies went down. We had a homicide. We had no leads on that. When the residents of that community realized that we weren't there to deport anyone and we started going door to door, we were able to get a lead. We found out where the suspect was and we were able to close out that homicide case because the citizens knew that as the officers were walking down the street, they weren't there to deport, that they were there to help. Again, as we look at 2017, the rules are changing. We need to look at that. If we're saying we are community policing officers and local law enforcement say that all the time, that buzzword, then we've got to realize that we've got to look at how we're going to work with our federal partners, immigration. I'm 100%, if it's a violent felony, then yes, that person is undocumented, then he or she should face trial and then be deported. But if it's a minor crime, we've got other things to do. You said earlier, my agency, and I can tell you most of the police officers, police chiefs, and the sheriffs in Florida, we're not going to the hospitals. We're not going to the churches. We're going to where our victims are, and our victims can come into us. Because our job is to make sure, one, that the community is safe, and make sure that our officers and deputies go home each and every night. And if we're not working with our community, that's not going to happen. So that's what we are doing.
And what about the tension between the current administration that's threatening to cut off funds if you don't cooperate the way they see fit with respect to giving information on somebody who's been arrested or honoring detainers, those kind of things? Are you feeling that yet in your jurisdiction? I understand that you don't necessarily run a local jail; it's done by the sheriff. But are you seeing that in your department and/or across the country that there's that increased tension?
And there is some tension there because a lot of the police chiefs and sheriffs are looking at those federal grant dollars. Am I going for the money or am I going to keep my community safe? If I need those extra dollars, then I have to follow exactly what this administration is doing, and we've seen some agencies that are going to say they're going ahead and going to assist the federal government. In Florida, the police department, we do not run the jail, so we can't say we're a sanctuary city. And if you have a warrant for arrest and you go to the county jail, and it's up to the sheriff then to run your name in a database to see if there is a federal warrant for you or a pickup warrant for your arrest. But other than that, local officers do not. My agency, we're still waiting for money from the JAG grant because it's going to go through a process to see if we say we're going to assist the federal government.
And what does that assist mean as far as to qualify for the burn JAG grant money?
And what they're looking for is they're saying if you stop someone or there's a suspect that you will hold that person for the federal government, for ICE. And our rule is if there's no warrant in the computer, then the answer is no. We do not have that authority. If you have a warrant for your arrest, then again, we will take that suspect with a document to the county jail, and it's up to that local sheriff if he or she wants to honor that warrant.
Thank you. Angela, I'll turn to you. So we've heard a little bit about immigration enforcement, increasing enforcement, this tension with police, local authorities. From the Attorney General's office perspective, from AGs across the country, what have you seen to be the current trends or litigation that's ensued over these new policies?
Okay, thank you. Well, for a number of years, even before the change of administration, California, like many states across the country, have been thinking, very hard about, the best public policy to pursue at the state and local level with respect to public safety and how to enhance trust between law enforcement and communities. Because I think the philosophy in California and in many jurisdictions across the country is that enhanced trust leads to more public safety, both for residents, both individuals who are here legally or undocumented, as well as for law enforcement. And in starting, in the 2000s, probably there was a little more increased attention to it. And in California, for example, in 2013, California passed a law with respect to somewhat limiting law enforcement's ability to be involved with federal immigration enforcement with respect to federal detainers, for example. And California law was passed, the California Trust Act, in which provided that local law enforcement could only detain an individual beyond their release date for 48 hours if a number of criteria were met. For example, state and federal law were followed, including the Fourth Amendment rights of the individual, and the individual had met the criteria, their criminal history met a certain criteria. Individuals generally who had been convicted of serious multiple misdemeanors or felonies. And so, that this has been a conversation that's been going on for a long time. Right. And the idea also that on certain issues that local law enforcement at the local level, not everybody may agree on what is the best policy, but law enforcement, either at the state or local level, know their communities best and know the challenges for the communities and what's going to lead for increased trust. So, the conversation I think right now that is happening is at the state level and with the attorney generals, and I know our attorney general is a real concern that the discretion that we believe that the state and local law enforcement should have in deciding whether it will voluntarily engage in federal immigration activities, whether that discretion is being taken away by the federal government, given some of the new federal policies or interpretation of federal immigration law. So, for example, in January of this year, the administration issued an executive order with respect to what we're all calling sanctuary jurisdictions, indicating that the Secretary of Homeland Security would have the discretion to characterize a jurisdiction as a sanctuary jurisdiction, And the executive order indicated that one way a jurisdiction could be deemed a sanctuary jurisdiction if they did willfully did not follow the rule 1373 that we discussed about the prohibition against the prohibition against restrictions on information sharing about immigration status, but also potentially the executive order suggested that one could be deemed a sanctuary jurisdiction if it was refused or decided or elected not to further assist federal immigration authorities. So there has that matter is in litigation at the city and county of San Francisco and the county of Santa Clara in California and other jurisdictions in the country did sue to challenge that executive order, and currently that executive order is temporarily enjoined. There's a preliminary injunction. As a state level, we've been very engaged on that. We have been supportive of those lawsuits by way of friend of the court briefs. We think these are very serious issues. And most recently, the issue that we are confronting are conditions that are being placed on the current JAG grants as well as the COP grants. These are grants that are given to state and local entities to engage in a number of very important law enforcement task force issues regarding recidivism, for example, or crime prevention. There's new conditions being placed on what we call the COPS grants, which are generally grants that deal with combating crimes with respect to drug enforcement. And conditions are being placed with respect to having jurisdictions certify that they will comply with 1373, as well as agree to allow immigration enforcement to access to the jails to interview individuals, as well as asking a commitment that local jurisdictions give 48 hours or notice before they release an individual at the request of the Department of Homeland Security. So depending on what jurisdiction you are in, your local ordinances may or may not allow that. The state law may or may not allow that under particular circumstances. But we have filed a lawsuit and we're in litigation regarding this because we don't believe that that is a lawful exercise of the federal government's authority. But that will be a matter that will be litigated in the courts.
So that would be that's Title 8 U.S.C. 1373, right? And
yes.
That's it in essence prohibits or in any way to resist a federal, state or local government or entity official or other personnel from complying with immigration laws, right? Or from assisting or cooperating with federal law enforcement officials. So it seems like there, if I understand it correctly, that section, to qualify for grants, you have to comply with that section and in other words, give notice and allows access to certain things. But the state government isn't required to do anything affirmatively. Am I correct in that?
Well, under federal immigration law, the only thing, there is no requirement on state or local governments, and the only restriction is that the state and local governments, as well as the federal government, cannot prohibit somebody from communicating or sharing information only about immigration or citizenship status. So we read that very narrowly.
Right.
But what is at issue is whether the federal government appears to be reading that provision more broadly to include other activities or other information.
Such as? Or obviously you want to...
Yeah, so, I mean, something that's important to keep in mind is that it has nothing to do, the 8 U.S.C. 1373 doesn't impose any obligation to comply with immigration laws. It's actually not, if you take it out of the context of law enforcement, like it's only been used in this specific context, but if you imagine what that would mean if it were in fact read to impose an affirmative obligation on state and local agencies to collect information, that means hospitals, schools, all different kinds of government agencies. And so that's why, I mean, it was tailored very intentionally and very narrowly because of 10th Amendment concerns and commandeering concerns. And actually, ironically, the only case where the only local policy that was litigated and which was found to be in violation of 8 U.S.C. 1373 was a policy in New York City under then Mayor Giuliani. So imagine how times have changed. So actually, I mean, what we're seeing is that we're winning in the courts on this essentially because, I mean, you asked, the opening question was sort of who enforces immigration law, and there's, I actually want to kind of acknowledge that there's like the silent actor of public impression or opinion that ends up enforcing how, like, it affects people's behavior, and that as a result can sort of be its own enforcer. So when you have a chilling effect on people seeking access to services, whether it's law enforcement protection or medical care or nutrition assistance, because they're afraid that those agencies are immigration enforcers, they're not, but there's the perception that they are. And so I think that the government's use of 8 U.S.C. 1373 is essentially a bullying tactic and a calling of the bluff. And they wanted a lot of localities to cave and fear the loss of funding. But it's very clear that that language was written with the understanding that there are constitutional limits. You cannot dictate states and localities what parts of federal law that they have to enforce. And the most recent Supreme Court opinion on this was actually related to the Affordable Care Act or Obamacare, where the Chief Justice Roberts said, you can't effectively threaten to withhold all Medicaid funding to states. That's a gun to the head if they don't want to expand Medicaid in those states. So what the Supreme Court has looked at and what the Constitution would consider is sort of the amount of funding at stake, the germaneness of the relationship between the funding that's being threatened and the acts that the federal government is trying to impose on the localities and the states. So I think we feel very confident that we're in the right on this legally and constitutionally, and so it's an incredibly narrow. If you had asked me 2 years ago, would anyone know what 8 U.S.C. 1373 is? Because it's also in the welfare reform laws of 1996. Like nobody, it's so obscure, and it's being used in this very politicized way.
Right. And Chief, how do you, I know that the Major Cities Chiefs Association has taken a position on this issue. As you know, there's pending legislation, H.R. 3003. No Sanctuary for Criminals Act, which talks specifically about these issues. How do you see the law enforcement community? Why is it important for the law enforcement community to come out against that proposed legislation?
And again, it comes down to if we're actually saying we're doing community policing and we're going to do that, then we need to do that. And the major cities have spoken up, and we are going to stick by that. Because again, we need to build a relationship with our community and build that trust. You always say everybody has a toolbox, and if the only thing you have in that toolbox is a hammer, then your serious problem is a nail. You need to look at other things that you have in your toolbox so you can address those issues. Because not everyone in that community that you're trying to get to know, that you're trying to build a trust with, are committing a crime. So again, what we're looking at the major city police chiefs is if we start enforcing these laws, then everyone's going to go back into their homes, and we're not going to be able to solve any of our crime issues. And again, like I said earlier, then you're going to go back to where we were back in 2000, where we are going to have that organized crime again. We are going to have these landlords that are misusing people, and people are not going to come forward again. And that crime that we talk about, just because, and everybody's going to tell you, well, crime is going down. Crime isn't going down. Crime's going down because people are not reporting it. Then people know they can take advantage of the people that are undocumented. And we'll be right back to square one. So if we want to continue to build that trust, we need to stand up as a police chief organization and say, no, we're not going to do this. And I think a lot of chiefs are saying, no, we're not going to do this because we are community policing.
Has there been much conversation with the prosecutorial agencies about that? Do you see is there a link to try to get political support on those issues?
I think the political support is there. Again, if you're talking about someone that's undocumented and committed a violent felony, I think you will see everybody coming to the table and say, this is what we need to do. But at the same time, we should not be out being a force multiplier for ICE to go check on schools and to check on these places to see who's documented and undocumented. I know a while back they were looking at reports, they wanted us, law enforcement, to start documenting if the victim was documented and undocumented, and a lot of police chiefs and sheriffs came out and said, no, we're not putting that in our police report. It's just who the person is, their name, their date of birth, and we're not putting that in our narrative.
So Angela, can you expound a little bit more on what's the current state of litigation? I know you mentioned the Santa Clara, San Francisco, City of Chicago is also involved in litigation. What's the latest, if you will?
Sure.
On that litigation?
So,
And what are the issues that are being
Okay.
specifically raised?
okay. So, as I mentioned earlier, there is the litigation over the executive order, and so that right now has been enjoined by a district court in the executive order, that aspect of the executive order that dealt with sanctuary jurisdictions and the order that jurisdictions could be labeled as a sanctuary jurisdiction and be ineligible under funding under the executive order itself. Or the executive order also talked about, an enforcement action could be taken against a jurisdiction who hindered federal immigration activities. That has been preliminary joined by the district court, and that matter now is before the Ninth Circuit. And so other jurisdictions that had filed with respect to that matter was Richmond. There was a lawsuit filed in Massachusetts, as well as a lawsuit filed in Washington. And those matters, those last two have been stayed pending the appeal. Mm-hmm. And in the funding, what we call the funding litigation, and that deals with the conditions being placed on the JAG grants or the COPS grants. The first jurisdiction that filed a lawsuit was the City of Chicago, and they filed on a number of grounds, but they did obtain a preliminary injunction on 2 of the 3 conditions. And the conditions that had been imposed on those grants, where jurisdictions would have to agree to abide by those, was the condition about providing, at the request of Department of Homeland Security, 48 hours notice before releasing an individual, and allowing Department of Homeland Security to come into jails to interview the detainees. And so that has been there is a nationwide injunction with respect to those 2 conditions, and right now there is litigation in the district court, and it may already be in the circuit court about the scope of that injunction, whether it should be narrowed or it should continue to be a nationwide injunction. And then there will be an appeal on the merits. Of
course.
The state of California, we did sue with respect to those the 2 conditions that I just mentioned, and then we recently amended our lawsuit to include a challenge with respect to the condition that jurisdictions certify compliance with 1373 in light of what apparently is the federal government's interpretation of that provision. And so we are in that case. Philadelphia also has a lawsuit on these issues, and the city of Los Angeles also filed a lawsuit on this issue. So that is very active litigation, and that will just be proceeding probably fairly swiftly, I imagine. And so, we'll be, in these cases, they raise, very significant issues with respect to separation of powers, with respect to, are these, in our view, these are conditions that would be a matter, if they could be placed, it would be placed by Congress, not by the executive. There's issues with respect to the spending clause that were mentioned about the relation between these requirements, which really relate to civil, immigration enforcement is primarily civil in nature, and these monies that are going for law enforcement on criminal issue matters. Whether these provisions, when they were added, they are, in our view, the decision to add them was arbitrary and capricious, which is an issue under the federal APA. So that's another claim. And then we're also, in our litigation, seeking a declaration that California's laws, we firmly believe that we actually are not in conflict with 1373. California does have, like I mentioned, we had the Trust Act. We recently just passed new legislation called the California Values Act, which does broaden the limitations on local law enforcement, and, for example, does limit when local law enforcement can provide notification of release dates and times to federal immigration authorities, and it is dependent on whether that activity would be in conformity with federal and state law, and whether the individual at issue has a particular criminal history background, and the statute has, there's a broad area of, or category of felonies and other crimes that are covered by that in those circumstances, local law enforcement, they're not required to provide the notification, but they would have the discretion to do that. So in California also, like many jurisdictions and also like the federal government, has some confidentiality laws in on very discrete issues. For example, and relevant to the panel on hate crimes, California, back in, I think it was 2005 or so, passed a law with respect to hate crimes, and that victims or witnesses, with respect to victims or witnesses of hate crimes, law enforcement is not to report their immigration status to federal immigration authorities, or cannot unless they have been charged or convicted of a crime. So we believe statutes like that are within the states, or if it's an ordinance, local jurisdictions' lawful ability to pass. We believe that not allowing, first of all, we don't believe that 1373, USC 1373, is ever intended or should be read to cover these very limited confidentiality laws. We believe that reading 1373 so broadly, it doesn't make sense when you analyze it within the INA. But even if it were to be interpreted so broadly, then we believe there's a 10th Amendment issue, and it would violate the 10th Amendment. So those are the issues that are going to be litigated in that case.
So let me take a step back here. We've talked a little bit about sanctuary cities, so I'm sure there might be some popular misconception, right? You think of a sanctuary city like, okay, it's free reign, you can do whatever you want, nobody can touch it, but that's not really the case. So, Abidi, you want to talk a little bit about what constitutes a sanctuary city, why they are called a sanctuary city, and then I'm going to come back to you, Angela, talk a little bit about the sanctuary state pursuant to Senate Bill 54 that was just signed by Governor Brown.
Sure. I think that regardless of your feelings about what limited detainer, or, policies that limit the role of local law enforcement's entanglement with federal immigration authorities, I feel like the one thing everybody agrees on is that there's not really any uniform definition of the term sanctuary. And I think for a lot of law enforcement agencies around the country, some of their policies are born out of strong relationships with community advocates and really feeling strongly about the policy aspects of it. But many of them adopted those policies essentially to insulate themselves from exposure to legal liability and for Fourth Amendment violations. And so I think that they rightly feel like both sides of this issue politicize it, and for them it's really a matter of we don't have the resources, the expertise, nor do we want to incur the costs of violating someone's constitutional rights. So the word sanctuary is very some of you may know, it has its roots for many in the faith movement, and for places of worship offering sanctuary or safe spaces to Central Americans during the 1980s. And so for those communities, it's very proudly used to say these are policies that are meant to limit people's exposure, their vulnerability to deportation or immigration enforcement. And there are certain law enforcement agencies that say that. There are certain cities that say we're a sanctuary city. There's some that say we're a Fourth Amendment city, because we don't want to mislead people into thinking that we can completely insulate them from any exposure to ICE enforcement activities. So, and then some people use it to suggest that localities, that it's a term of obstructionism. So, I mean, it sort of means everything and nothing at the same time. And I'm always a proponent of use whatever it is that works in your community and that people want to use. But at the end of the day, to me, the people who adopt these policies are upholders and defenders of the Constitution. They're legally in the right. And it's absurd that they have to be essentially litigating and challenging and fighting the federal government to honor the Constitution with them. Something that's very interesting is, I think it was about 2 weeks ago, ICE Director Tom Homan gave a speech at the Heritage Foundation, and a lot of the posturing of ICE, and certainly in the first few months of the year, before we were seeing lawsuits filed or in the early stages of the litigation, they were essentially trying to make it again seem like these localities are obstructionists, that but for the St. Petersburg policy or whatever, that they would be able to enforce federal immigration law, when that's obviously false. Nowhere, not even in the sensitive locations, is the application of federal immigration law suspended. It's just not. It doesn't mean that people can come in and do whatever they want, but it obviously trumps local policies and state policies. And what was so interesting is a couple weeks ago, in this speech to the Heritage Foundation, ICE Director Homan said, they issued a very chilling, I'll let you talk more about it, but they issued a very chilling statement in response to California passing this new law recently. They sort of talk about the inevitability of if we can't go to the jails, then we have to go everywhere else. As if they would have only stayed in the jails, but for these limited detainer policies. And so what he actually said was the places that have these policies, the policies that uphold and honor and protect the Constitution, that those places say that they're making their communities safer, but actually they're making their communities more dangerous, and they're exposing their community members to even more immigration enforcement, because now we have to go out into the community, and because we engage in collateral arrests, because we have no priorities, we're now actually picking up more people as a result of these so-called sanctuary policies. So it was vindicating, not that I don't want that vindication, but it was like a recognition in that audience that's been totally disingenuous of them to say all along that it's the sanctuary policies that are obstructionist. So the meaning, to me, it doesn't matter what you call it. The point is that the policies are in the right legally. And so I think it's a very politicized term. I mean, we don't take a position one way or the other. Like some people say, safe cities, safe zones. We've created model policies for K through 12 and higher education institutions, as well as healthcare providers, to have safe zone policies. Again, not because, I get asked all the time, but what you're proposing, we can't change federal immigration law. No, but in the same way that you train individual community members to physically play out, an exercise of stating your rights and knowing your rights, that we're asking other institutions, even the ones, sadly, that are supposed to be insulated under the safe, sensitive locations memo, that, we're explaining to them, you can escalate things. Part of this is really that we have pretty brazen activities by this administration and retaliatory activities. And so it's really, the onus is not just on law enforcement, but schools, hospitals, etc., state agencies, to really say we're gonna make sure that in the court of public opinion it's seen when you violate our rights as an institution or individual rights. So it's less about the meaning to me, and it's more that just again the legality of the policies and how it's being used by both sides.
Well, the federal government seems to make a big deal about sanctuary jurisdictions in the context of raids. Just last week, you may have heard this Operation Safe City. They went out and arrested about 500 undocumented immigrants in so-called sanctuary jurisdictions, which unsurprisingly includes New York, Los Angeles, Philadelphia, Denver, Washington, Baltimore, Cook County, Santa Clara, Portland, and Massachusetts. So it was a planned, a very targeted raid, and that was on the heels of a wider raid. They intended to go out and arrest 8,400 people, but it was because of Hurricanes Harvey and Irma that messed up those plans. So that's a very active, and I think that's just kind of the tip of the iceberg. I expect that there'll be more such planned raids. And then speaking of sanctuary cities, now I'm quoting from this, a very helpful resource that will be in the materials. The National Immigration Forum puts out a weekly legislative bulletin, which gives you the latest on what's out there. And today's legislative bulletin comes out every Friday. Committee on Immigration under the New York City Council agreed unanimously to pass a bill that will prohibit local law enforcement officials from cooperating with U.S. Immigration and Customs Enforcement agents. The legislation would limit federal agents' ability to use city resources to detain unauthorized immigrants. The full city council is expected to vote in favor of that bill. So you see that there's a growing tension, and it's really at a constitutional level, right? Separation of powers, the Commandeering Act. So going back to what I mentioned before, the Sanctuary State Act, what does that do with respect to 1373, if anything?
Well, and we don't call it the Sanctuary Act. And it's, the California Values Act, SB 54.
Right.
And,
but the media calls it
yeah,
that,
the
right?
media, and I'll just step back, the issue about kind of misinformation, and the confusion out there about, what is a sanctuary jurisdiction, as you were discussing, and there's no one definition, and, early on, a number of states, including California, with New York, let's see who else, D.C., Oregon, Rhode Island, and Washington, and I believe these are the materials.
Yes.
We got together and put together a report. It's setting the record straight on local involvement in federal civil immigration enforcement, the facts and the laws, because we do believe that, the public is, hearing so much information about, sanctuary cities and having this impression that we're protecting criminals and dangerous criminals, and that we are, refusing to follow federal law, and we really feel very strongly that that is a false narrative. And so I would encourage everybody just to take a look at this report. We're really proud of it, and it has a lot of testimonials, from local law enforcement and other officials and studies, and just to really explain what are we really talking about. What really is the federal government talking about, or others, when we talk about sanctuary jurisdictions. And it really varies. It could be, a jurisdiction that just has made a symbolic gesture, supporting immigrants, or it could be a jurisdiction or a state that's just somewhat limiting some discretion of local law enforcement in circumstances, or it could be, a jurisdiction that has, very limited policies. It's not a one-size-fits-all. And so, I think, though, the same misconception is happening with respect to California's new legislation, the California Values Act, SB 54. And, I think if people, once, you read it, you can see that the legislature, really, there's a very reasoned, considered balancing that was done and ultimately enacted in determining what would be the best policy for California. It might not be the best policy for every state, but for California, we're convinced that it is based on, years of experience in our state. There is I think, a misconception, or that you'll hear that, California is refusing to allow federal immigration authorities into our jails. And, that is not the case. California, it is a law prior to our Values Act, but that is somewhat modified in our Values Act, that what California does with respect to interviews that are going to happen in our jails, or ICE requests to interview individuals, we simply require our local law enforcement to provide individuals with information about them, and what their rights are, and that they have to agree, or they could have an attorney present, for example. So there's some written consent form that is provided, but the law does not disallow the access to the jails. And with respect to 1373, the statute has an explicit savings clause that nothing in the statute prohibits or restricts the sharing of the information that's covered by 1373, which is information about an individual's immigration or citizenship status. So the Values Act explicitly accepts that is federal law currently, and so that is in the statute as well. So, and again, with respect to notification requests, as I indicated, it is not just this blanket refusal on the part of the state that law enforcement cannot provide information about an individual's release date to federal immigration enforcement. There are, under the law, is a great amount of circumstances in which a local law enforcement agency can exercise its discretion if it wants to provide them. So again, I think what's unfortunate, because I do think there's a lot of misinformation out there in the public. It is a complex issue, but that kind of, the misinformation, in my personal view, also just drives the, kind of the fear that the state or local law enforcement, they are going to just buckle under the pressure, and they are going to start being more involved in actually engaging in federal immigration activities, which, it just is, at least in our experience, really does create situations where people are going to be very fearful to report a crime or even be a witness. And the other issue that we haven't talked about, the building of trust has been very important in the enactment of these laws and this public policy. There's also the issue of, scarce resources on the part of local law enforcement. And, when local law enforcement is asked to detain individuals or to engage in federal immigration activities, that comes with a price tag. Training, personnel, space. And it's very clear from our California Values Act that is another thing that's very much animating this legislation, is reserving resources so that law enforcement can use those resources to combat crime, not engage in civil immigration activities.
Right. There's also some other resources in the materials, one in particular from the Immigrant Legal Rights Center, Searching for Sanctuary, and the toolkit, Sanctuary City Toolkit, that I'll add to the materials, also has all the legislation, a lot of information about those enforcement activities. We haven't touched upon 287G agreements. Why don't you, either one of you, talk about what that is and what's happening with those? Everything?
Sure.
What are 287?
So 287G is a provision of the Immigration and Nationality Act. It's a section that basically deputizes local law enforcement to play the role of ICE agents. And they kind of, there's two models. There's the jail model, where officers in the jails can do that, versus what's called the task force model, which is basically officers on the street. And probably the most notorious example of the problems of the task force model are under Sheriff Joe Arpaio from Arizona. There was, under the Obama administration, a decrease in the use of 287G agreements. Basically, it's the localities enter into a memorandum of agreement with the federal government. For some localities, the costs to train and to provide your personnel time and to have other people sort of cover while you're training officers to be 287G deputized, it ends up actually that the localities incur the costs of that, and they don't get completely reimbursed by the federal government. So from a cost perspective, a lot of the advocates said, why would you choose to engage in that? Again, it's immigration is civil in nature. You're a local criminal justice law enforcement agency. And also it will scare people for all the same reasons the chief mentioned at the beginning, that, if someone walks into a room, they can't tell by looking at this panel what our immigration status is. So it makes all of us more vulnerable to crime if someone thinks that they can really act with impunity against people because of their lack of status. So what we've seen is that, actually you used the term force multiplier. That's exactly the phrase that DHS uses to describe the 287G program. For them, they see it as a way to get more ICE agents, essentially, embedded in the community. We have seen that under this administration, they started out, I think it was about 32 existing memorandum of agreements that were in place at the end of the Obama administration coming into this one. And they said that their goal was by the end of this calendar year to triple them. They have done them sort of en masse. We've seen places that have really notably shameful track records of racial profiling and police misconduct, that those applications are sort of sailing through. There's currently about 20 some that are going to be under consideration by DHS in a couple weeks. And they are very, very close to meeting that goal of tripling the number of 287G agreements. And it's really important because, I feel like at the beginning of this administration, people would ask, like, how is this different than, there was still 287G under the last administration, or Obama was sometimes referred to as a deporter-in-chief, or we still had record numbers of detention. And it's the confluence of all of the things that we're talking about, coupled with, again, just sort of the gloves are off attitude from ICE and from DHS generally, and that there is like the whole Safe Cities operation that you mentioned. It's intended to be intimidating, and it's intended to be retaliatory. And what's interesting is that a lot of places that don't have quote unquote sanctuary policies were also targeted in that, but it's the PR machine of DHS currently is really to try to show that they are willing to be very, very vindictive, that they have released misinformation about which localities are declining or cooperating with detainers, and it's really I think just shows a very different climate. So when you have that, it really sends the message that even for places that don't currently have a track record of racial profiling or other problems at the local level, that there's not going to be accountability or oversight. There's just no investment in that from DHS right now. So it's very, very concerning, because for all these places that have good policies at the local level, there's other places that are really embracing the 287G model. There's also misinformation around what the legal authority of ICE detainers and ICE warrants are. So a lot of times DHS is actively marketing to localities by saying, hey, if you deputize your local law enforcement, you don't need to worry about all those lawsuits that people were filing that resulted in liability for violating people's Fourth Amendment rights, because our civil detainers, see, it says a warrant on it. So you're fine. Right. And so it's led to, it's understandable that if you are hearing from the federal government and they're courting your interest in entering into an official relationship and agreement with them, that they're telling the truth. It's understandable that you would assume that. And then we get questions, or other folks, networks that we work with will get questions saying, they're actively saying that the use of the detainer in a civil warrant, like that cleanses the legal question and the constitutional question. So we're good, right? That's just a real concern around 287G, is that it's sort of handing off the problem, and really, they sell it as a force multiplier. And when you bear in mind everything that we've said, bear in mind that there are no longer, on January 25th, there was this executive order that pretty much eliminated the concept of prosecutorial discretion, and said anyone and everyone of the 11+ million people who are here without status, we're treating you equally. we view you as one and the same. Whether you've been charged with a crime that's later going to be dropped, as often happens in cross complaints with domestic violence disputes, whether you're a minor, whether you've been here for a long time, does not matter. You're all one and the same. And that, coupled with the fact that you've got DHS aggressively asking Congress to expand their force and to ask for more money to do their work. So, I mean, all of these things in combination, it's hard to sort of like look at in isolation. I mean, I think 287G alone, if you say they've tripled the number or they're on track to triple the number of agreements, that alone is startling. But I'm always trying to really sort of connect the dots between all of these things, because they really are, you can have a great local limited detainer policy, but then you've got folks who are being sold 287G as something that's good for the community, it's good for law enforcement, and that it's cost effective.
And specifically, the proposed legislation under HR 3003 grants them immunity and says that if anybody's going to be sued, that the defendant is the United States of America, federal government, and not the local government. So it's specifically catering to that issue. Any other thoughts on 287Gs, Chief or Angela?
Well, 287G was started 17 years ago, and it was for violent felonies, and every officer, every agency could at least get one deputized person. Like you said, now they're trying to deputize all the officers, so all the officers have that privilege. And it should be, again, it was made, again, 17 years ago, because it was for a detective at a police department. He or she could be able to talk to someone, a suspect with violent crime. But if you, again, they'll reach those numbers. I have 562 people. So you think about it, if you deputize 562 people, you just multiplied your force.
Right. Well, we're getting close to the end of our time here, so I'll open it up for questions from the audience, if there's any that you may have. Yeah, Sandy.
Chief, is there any acknowledgement by the administration to folks like you, to chiefs of police and sheriffs or prosecutors, of the negative impact on your ability to do your job to police by these, enhanced immigration enforcement efforts that they're trying to stuff in?
Yeah, you get a lot of police chiefs and sheriffs that are speaking up, just saying, no, we can't do this. We've talked about community policing, we talked about building trust, and if we move forward with the way it's being produced or pushed, then we're gonna lose that trust. And like I said earlier, people are not gonna talk to us anymore, and we're gonna be right back to where we were 17 years ago.
And what's the reaction from the administration?
Again, some people are listening, some people are not listening. So I think it's just going to keep the chiefs and the sheriff, keep pushing it, talking to our senators, our Congress people, is saying this can affect our communities. If you're talking about keeping the community safe, then we need to put those boundaries up.
Right. In fact, in the materials is a letter dated June 26th of this year from the Major Cities Chiefs Association outlining their objections to 3003 and why they feel that this legislation isn't necessary, that you can do your job better without it. The other actors, if you will, in the criminal justice section system that we haven't talked about, of course, are the defendants, right? And we have how are defendants being affected by increased enforcement? Well, there's of course detainers. If you look at the stats in the federal government, the leading charges by the federal government, close to 30%, are drug cases. The second leading charge, by just 1 or 2% is less, are immigration offenses. So, almost third of all federal prosecutions across the country are immigration-based offenses. They're affected, of course, they're guided, in terms of sentences, are guided by the sentencing guidelines. There have been some recent changes to the guidelines which have taken effect as of last November, Section 2L1.1. And the calculations are a little bit different, and it always takes into consideration prior record. If you committed your offense with a prior record or after your first deportation. They're pretty complex, but there's enhancements in there for more convictions and more illegal reentries. So the other enforcer, if you will, of course, are federal judges and our prosecutors who will charge these cases, and then what the federal judges do with respect to sentences for illegal sentencing. There was modifications because I think they were particularly harsh before, with the up to 16 level enhancements. I think the Sentencing Commission did a study to determine what are the judges doing. The judges in general were departing downward because it didn't make sense for them to say, well, this person is going to wind up being deported. Why should I give him a 120-month sentence at this outrageous cost of incarceration? So there's been some changes there. We don't know yet what the prosecutorial levels are going to be because, as you heard earlier, not all U.S. attorneys are in place yet. It's a very localized decisions. The course along the border are the vast majority of the 1326 cases. So that's yet to be seen. But with the increased emphasis on immigration and sanctuary litigation, I think we're going to see probably an uptick of criminal prosecutions, and we'll see what the sentences look like down the road. Any other questions before we wrap it up? Yes, sir.
Quickly, are you seeing any impact on the U visa program out of this?
Do you mean in terms of
So whether
certifications?
they're going to cut back on granting U visas or the request of the local prosecutor?
So, does everybody know what a U visa is?
Just
Yeah, so in 2000, there was federal legislation passed that created this new visa, the U visa, for victims of serious crimes. And the idea is that it was for basically if you were cooperating with any law enforcement agency and you got certification, it could be from a judge, it could be from a child protective services agency, local law enforcement, district attorney's office. And if you met certain criteria and could show that you suffered substantial harm as a result of certain crimes, then you would be able to get this humanitarian-based visa that would eventually get you a green card and citizenship. And many of the applicants, not all, but many of them are domestic violence survivors and their family members, but certainly applies to stranger crimes as well. And the certification ultimately depends on the local agency or whoever is issuing it and if their willingness. I think your question is how is USCIS, which is the benefits division of the Department of Homeland Security, how are they reacting? So historically, U visa applicants, even if their application is denied for some reason, there's the charging document in immigration proceedings is called a notice to appear, or an NTA. And so the NTA guidance was always that even if you were denied a U visa, you wouldn't get NTA'd and then referred to immigration court. So that's different than, say, asylum, where 100% if you are denied asylum, you'll get a second chance at the apple when you go in front of a judge, but if you apply affirmatively and you're denied, you will absolutely be referred. So that's why people should take applying for asylum very seriously. And with U visas, they didn't want to discourage that cooperation with local law enforcement agencies. And so they said, even if we deny it, we're not going to refer you. There's currently there's going to be a revision of the NTA policy, so it's unclear. Yeah, I mean, I don't know if that's something you all have talked about in terms of your concerns about what that means for issuing certifications.
And we said maybe an increase because everybody may start applying for that was robbed by a certain person but not give enough information, so it could go up. And it's going to either be up to the chief or the sheriff, whoever, that can sign off on those visas.
Any other questions? Please join me in thanking our panel for today's